Just want to welcome everyone to today's webinar, which is hosted by the Oregon Justice Resource Center. The Oregon Justice Resource Center, or OJRC, is a nonpartisan nonprofit law firm that provides pro bono legal services and support to nearly 700 Oregonians each year and advocates to protect the civil rights of individuals who are impacted or harmed by the legal system. Today's webinar is an introductory conversation about survivor-defendants and the issue of criminalizing survivors, and Senate Bill 1070, which is a bill that we've introduced with Senator Campos, and it will be a first step towards ending the over-incarceration of survivors. Senate Bill 1070 is on behalf of survivors of domestic violence who've long been overlooked. Please note, we just want to recognize at the outset that because we're talking about abuse and harms, this conversation may involve anecdotes and comments that could be activating or triggering. We have great panelists today, and I'm excited to be able to participate in this conversation. I'll be moderating it. If you have any questions, please put them in the Q&A, and we'll try to answer them along during the conversation or at the end if we have time. But I just want to go ahead and get started because we have these great speakers here today. And before we get started, I just want to introduce myself. My name is Bobbin Singh. I'm the Executive Director of the Oregon Justice Resource Center. And again, excited to be part of this conversation and moderating it. So I'd like to start with introductions. If you could tell us who you are and a little bit about the work you do, that'd be great. We'll start with you, Professor Goodmark.
Hi, everybody. I'm Leigh Goodmark. I'm the Marjorie Cook Professor of Law at the University of Maryland Carey School of Law, where I direct our gender violence clinic. Our clinic represents criminalized survivors in cases involving parole and commutation and post-sentencing modifications. All of our clients are survivors of some form of gender-based trauma, and I've written a book called Imperfect Victims, Criminalized Survivors and the Promise of Abolition Feminism that describes our work and the bigger issue of how the legal system treats criminalized survivors of violence.
Great, thank you. And I have a copy of the book right here, so if you're interested, I'd recommend getting it, going out and getting it and reading it. I've only skimmed through it, but it's a really great book, a lot of good information. Julia?
Hi, everyone. My name is Julia Yoshimoto. I'm an attorney and the project director for the Oregon Justice Resource Center's Women's Justice Project. Before becoming an attorney, I worked in social service organizations for a number of years, primarily assisting women who have been marginalized in the community, women with severe mental illness, struggling with drug addiction, and many of them lacking resources. And I think that I came to this work at the Women's Justice Project because of the experiences that I had assisting those women and seeing how the harms that they endure by their voices and their stories being dismissed, and the harms that extend out to their children and their families and to the broader community. The Women's Justice Project's core work is providing legal services to people who are incarcerated at Coffee Creek Correctional Facility, which is Oregon's only women's prison. And although our legal services primarily addresses non-criminal legal issues, we often hear about women's experiences through the criminal legal system. They'll tell us stories about the circumstances of their crime, how they experience the criminal process and their proceedings, and the impact that the criminal system is having on them and their families. And because this is a perspective that's often missing from the conversations about criminal justice issues, the Women's Justice Project works to lift up these women's voices and bring their perspectives and their experiences to the conversation through public education, by developing creative litigation opportunities and advocating for policy change.
Great, thanks, Julia. And Mallory?
Hi, my name is Mallory Maloney. I am a staff attorney with the Oregon Justice Resource Center's Fair Law Project, and I previously worked as a public defender representing people facing mandatory minimum sentences.
Thanks, Mallory. And you can find all this information on our website, and obviously information about Professor Goodmark. Book is in the chat, and you can find more information about her book and her work on her webpage as well. And we'll have someone put that in the chat as well for everyone. So just starting off, Julia, I'm wondering if you could just provide some more background to your and OJRC's work on the issue of survivor defendants or the criminalization of survivors. How did you get here professionally, and how did that all lead to Senate Bill 1070?
So the Oregon Justice Resource Center's Women's Justice Project has been looking at this issue of criminalized survivors or survivor defendants since it started in 2015. And this was largely because of the stories that I was hearing from the clients that I had at Coffee Creek. Like I had mentioned, most of our work is through non-criminal legal assistance, but women will often tell us about the circumstances of their criminal cases, what led them in, what they saw as their pathway to incarceration, and how they're experiencing the criminal system. And they'll oftentimes the Women's Justice Project attorneys could be the first time that they had this space to really talk about their experiences and to share their stories to somebody who was really listening and wanted to know more about their histories. And what a very common theme in the stories that we heard were about domestic abuse and how that contributed to their convictions and how that put them on the pathway to incarceration. And with that often came comments about how they felt like their domestic abuse history was never considered or adequately considered in their cases. We would commonly hear that nobody ever asked them about it, or it just never came up for a variety of reasons, or that if they did bring up their history of abuse or the domestic abuse, oftentimes still in that abusive relationship during the criminal proceedings, if they did bring it up, their defense attorneys didn't feel like they could do anything with that information, and didn't feel like it was worth pursuing and investigating more. And in hearing these stories of women in prison for actions that they've taken really out of a sense of survival or a sense of protecting themselves or their children, it wasn't uncommon to hear that our clients were incarcerated for crimes that their abusive partners had committed. And when you listen to the full stories and you really understand sort of the lesser culpability that they have in the crimes for which they're convicted, and you compare that to the sentences that they are serving and the impact that those sentences are having on their children and their families, there's just a very profound sense of injustice, that there is something going terribly wrong with the way that we are treating survivors. And so our work really has been grounded in all of these stories that we're hearing from our incarcerated clients. And over the years, we just continue to listen to these stories, continue to research and look into how survivors are being treated through the criminal process, paying attention to some of the things going around the rest of the country. We've held two-day conferences on this issue at the Oregon Justice Resource Center. We did a survey of over 140 women in Coffee Creek, which revealed even more information to us about this population. So this has been an issue that we've, over the years, just been looking at, and it sort of all culminated in this opportunity with Senate Bill 1070 to advocate for a meaningful change in the way that we're treating survivors of domestic violence who become criminal defendants.
So you just actually started to answer my next question, but you've talked about survivors and how they become defendants. And just so people really understand this term, because this is a term that we use here, but not like a nationally understood, like a recognized common term. But what do we mean specifically by survivor defendant? Professor Goodmark talks about criminalization of survivors, but what are we talking about very explicitly?
So when we use the term survivor defendants, we're talking about survivors of domestic violence who become criminal defendants because of the domestic abuse that they suffered. And these are survivors who have been or will be prosecuted and sentences for, like I had mentioned, actions that they have taken largely out of a sense of survival or under threat or trying to protect themselves or others. And there are other terms that people use. I do like that term criminalized survivor that Professor Goodmark uses, and I believe others use as well. For us, the use of the survivor-defendant term recognizes the history of the domestic abuse for that defendant while they're going through the criminal proceedings, and it recognizes it as something significant that should be considered by the system throughout that criminal defendants, throughout that process. Because what we see in these cases is that oftentimes, if not all the time, that a survivor of domestic abuse becomes a defendant. That whole sense of needing to provide a survivor with safety, with care and support really gets stripped from them as soon as they come into the system as a criminal defendant. And so for us, the use of the survivor defendant recognizes them as a defendant, but recognizes the significance of that domestic abuse that they survived.
Thanks. And, I want to jump to Professor Goodmark, and I want to put a pin in this. And I want to ask you about this just a little bit later. The terms that we're using: domestic abuse, domestic violence, intimate partner violence. So, I just want to put a pin in that. But and also this idea of criminalized survivors and survivor defendants as well. Coming back to that. But I think at the outset, what would be really great is, Professor Goodmark, if you could tell us about your background and how you came to write Imperfect Victims and the work that you're doing in Maryland.
I started representing victims of violence when I was 25, I believe. Came out of law school after a clerkship as a young legal services lawyer. And for the last 28 years, that's what I've done. Primarily in the civil system, up until about 10 years ago, and even kind of tailing off into the last 2 or 3 years. And when I came out of law school, I was a carceral feminist. I think that's a descriptive term, not an insulting one. It's somebody who believes that the carceral system is the way to intervene to stop gender-based violence. And that was me. And that was very much the prevailing attitude of the time. People thought that the criminal legal system would be the way to address intimate partner violence, to keep it from happening. And we endorsed that. We endorsed it through the Violence Against Women Act and in a number of other ways. But very quickly, my clients started to say to me, this isn't working for me. It's not working for my family. I don't want my partner locked up. I don't want to lose the support in co-parenting, the economic support, the community support, all of the things that are lost when somebody is criminalized. And almost as quickly started to see my clients being incarcerated themselves. So they might call the police, and the police would come to the scene but not be able to make a determination as to who the primary aggressor was, or might say, well, I see injuries on him, but I don't see any injuries on you. Or my client was Spanish speaking and the person who they were involved with was English speaking. And so only one of them was understood by the cops who came to the scene. And for whatever reason, my clients were starting to be arrested. I went into academia in 2003 and started looking at the many ways that the legal system fails survivors of intimate partner and other forms of gender-based violence. That's been my scholarly work there since then. And also started to look at this question of criminalized survivors through the case of a woman named Dixie Shanahan, who was sentenced to a mandatory 50-year term of imprisonment for killing her abusive husband. And although I wrote back and forth with Dixie a little bit and worked a little bit on her commutation campaign, I still wasn't doing the work in any kind of meaningful way. About 10 years ago, though, I came to the University of Maryland and started a new clinic here, the Gender Violence Clinic. And in that first year that I started the clinic, I had the case of a criminalized survivor seeking parole. And that for me was the moment when I said, oh, this was the work that I was supposed to be doing. And since then, our clinic has increasingly done work for criminalized survivors to the point where now that's the only work that we do. And as I said, we represent survivors in parole, commutation, both the state and the federal level, in post-sentencing proceedings, in sentence modification, and so on. And so the book really reflects both the trajectory of my scholarship, which started with, oh, I think we could probably fix what's wrong with the legal system, to, oh, I really don't think the legal system's working at all, to, oh yeah, we have to think about something altogether different, because the harm that the legal system is inflicting on victims of violence, it can't be undone. It's kind of innate in the system. And that's very much informed by the work that my students and I do with criminalized survivors. The book itself came out of a group that I was co-facilitating at our prison, the Maryland Correctional Institution for Women, where we were looking for a project to do with a group of lifers, and we came to the decision that we would write a book together. They would write their narratives. I would frame them using the law and the social science research. And although the warden approved the project, the Maryland Department of Public Safety and Correctional Services did not. And so the clients asked me to go ahead and write it anyway. So in the book, what you see is a number of the stories of my clients, and kind of with their permission and with their blessing. And it's been really amazing to have them kind of come back and reflect on seeing themselves in the context of this bigger conversation about criminalized survivors.
So, I mean, you alluded to this in your opening remarks here. Like in our experience in Oregon, it seems like this population of criminalized survivors has largely been overlooked by different stakeholders in the criminal system and by domestic violence advocates. Why do you think that is? I mean, that seems to have been, part of like what motivated you. Like we began to recognize this and see this as a gap in the system or a gap in the community and public officials. But like, why do you think this population is overlooked by all these different stakeholders?
I think in part, the population is overlooked because we don't want to admit how big the problem is. I think in part, it's not overlooked, but there's not commitment to do anything about it. So the anti-violence community recognizes that there is a significant population of criminalized survivors, but many in the anti-violence community are not willing to critique the criminal legal system because of how firmly enmeshed they are in that system. And things like the Violence Against Women Act, which create incentives for anti-violence agencies to cooperate, to collaborate with the criminal legal system, make it difficult for those same agencies then to turn around and critique the work that those systems are doing. And then I think for the system itself and for police and prosecutors and judges, they would say there is no problem because we're not doing anything wrong to people who don't deserve it. Because once a victim becomes a defendant, they are no longer a victim in the eyes of the system. We operate under a pretty strict binary. We only have one victim and we only have one offender. You don't get more than one. And so for, I think, actors in the system, once somebody comes into the system as a defendant, they don't see them as a victim anymore, and they will contort themselves in all kinds of ways not to see them as a victim. And then there's no problem to acknowledge because we're not criminalizing survivors, we're criminalizing defendants.
So, yeah, I mean, you mentioned like this, that this erasure happens of people's experiences as they become defendants. I've heard you talk about it as like a switch gets flipped, and and people don't see beyond that. What is the concern if we? I mean, you've talked about like people don't want to admit the problem's so big, or people are thinking that these are the people that are deserving. But what do you think is like the real fear driving that inability to see people more than that criminal offense that they're charged with?
If we admitted what the studies already tell us, which is that overwhelming numbers of incarcerated women and femme-identifying people and trans and gender nonconforming people, and really all people, but for the purposes of this conversation, we can use the survived and punished definition of criminalized survivors as women and trans and gender nonconforming and femme-identified people. If we acknowledge the numbers, which are that somewhere between 60 and 95% of those folks who are incarcerated are victims of some form of trauma, then we would have to acknowledge that we are punishing people who come with significant histories of harm in ways that are inherently traumatic. Prison is a trauma-inducing institution. And so we would have to admit that we are inflicting harm upon harm, and we would have to admit that we don't do a very good job of screening people for the victimization that they have experienced upon coming into prison in the first instance. And we don't do a very good job of figuring out who our primary offenders are. And we've used this very blunt instrument of the criminal legal system to intervene in all kinds of ways, because there are lots of ways that survivors come into the criminal legal system. The bill that you're thinking about in Oregon is, I think, gets at one part of the problem. The problem is actually much bigger because people come in as witnesses when we use material witness warrants to incarcerate people, and people come in when they call the police for assistance and the police lock them up anyway. And then people come in when they have done things that legitimately or illegitimately expose them to the criminal legal system in some way. So there are lots of ways that people come into that system in the first instance. We don't want to talk about that. We don't want to talk about the fact that we've done 40 years of training of police officers to very little avail, because police still can't figure out who a primary aggressor is and what the context within which that violence took place is. We don't want to admit, in the same way that we don't like to admit that we lock up innocent people, we don't want to admit that we lock up people who've been victimized. And so that just to have to confront the scope of that problem is so large. Like, if we really looked at who criminalized survivors are, we could not in good conscience incarcerate the vast majority of the women who are incarcerated right now. Beth Ritchie has said, I never met a Black woman who's incarcerated who wasn't a survivor of trauma. I haven't met a client who hasn't experienced some kind of trauma. And so I think it's just too big for people, and the way that they distance themselves from it is to use kind of tropes about who gets to be a victim and who doesn't, in order to say these aren't real victims, and so we're not really doing that kind of harm. And prosecutors see themselves as the voices of victims until those victims become defendants, and that's when the switch flips.
Yeah, I mean, we see that here in Oregon, and you talk about like some of the dynamics at play that kind of bring people into the system, but I'm wondering if you can talk a little bit more about some of the dynamics at play of how survivors may end up interacting with the criminal system, or committing acts that may be charged as criminal offenses.
Survivors come into the system as victims. They, for example, in the book, I talk about a woman who went to get a protective order and was upset because the magistrate wouldn't give her the order, and the magistrate in response incarcerated her for 5 days for her belligerence. The next year, she came back to get an order again and was told that it was too late to come in that day. She protested, and the same magistrate incarcerated her for 10 days, again, for her belligerence. Victims come into the system as witnesses. I've talked a little bit already about material witness warrants. I know that's not directly relevant to 1070, but I do think it gives you a sense of kind of the overall landscape, that when prosecutors want people to testify and those same people don't want to testify, prosecutors use what are known as material witness warrants to have them incarcerated pending their testimony. That can be a day, a week, a month, 6 months, and without any of the protections that attach to criminal defendants. So you're not entitled to a speedy appearance in court. You're not entitled to bail necessarily. You're held in the same places sometimes as the people who you're meant to testify against. And then people come into the system as defendants because they've fought back in self-defense. Is kind of the classic example, right, of the battered woman who fights back against her partner after years of abuse, but also because of things that they do under the coercion or duress of their partners. In the book, I write about one of our clients, Irena Pretty, who was incarcerated at age 18 after her abusive boyfriend used her to get entry into the store where she worked, and then told her to tie up her boss and the other person who was there. She told them that if they would just listen to him, nothing would go wrong. She didn't want to be there. She ran away as soon as she could. And as she ran away, heard gunshots. He had killed one of the people and hurt the other one. And she was incarcerated for 42 years for felony murder, even though she did not want to be part of the felony that was committed. She acted under duress, and she wasn't there when the people were killed. Felony murder gets lots of our clients into the system who aren't choosing to commit felonies, aren't choosing to be part of those actions, and also aren't committing the actual murders themselves. The problem, of course, is that duress is not in many places, in most places, a defense to homicide. So even if you are acting under duress, if you're made to commit a fairly serious crime, there's no way to use that defense. And so criminalized survivors face liability that way. Criminalized survivors come into the system for acts that are committed by their partners in other ways as well. Failure to protect is probably the best example of that survivors are incarcerated when their partners hurt their children because they have somehow failed to keep the same people who are abusing them from abusing their children. In some states, the sentences are ridiculously long for failure to protect, and That's true in, Oklahoma is probably the worst, but it's true for us in Maryland as well. And then we see people who come into the system because they're self-medicating in some way. So if they're engaging in property crimes, they're engaging in the use of illegal substances, oftentimes that is tied directly to their victimization, but nobody is having a conversation about that. And then we represent a number of survivors of trafficking who have been convicted of crimes related to their own trafficking, when they are forced to do things in a trafficking situation, or when they are doing things trying to survive and help those around them to survive. And those things are characterized as trafficking offenses, even though they're being trafficked at the time. So lots of different ways that people come into the system.
And Julia, I just want to bring you in on this just very quickly. I mean, the things that Professor Goodmark is talking about as far as how survivors enter the system. And since we're talking about Senate Bill 1070, specifically like the criminal system and when they're charged, are you, from your experiences and from the work that you've done, are you seeing similar things? And can you describe some of the facts that maybe high level facts of some of the situations that you're seeing?
So all of the examples that Professor Goodmark gave just now about how a survivor comes in as a criminal defendant, as she was giving them sort of names and clients that I've had sort of flash through my mind, because this is also what is happening here in Oregon. I mean, I can think off the top of my head of a number of clients who in that more classic situation were defending themselves against their abuser and either committed a homicide in doing so, or were convicted for assault at various levels. And I think about how over time with the lower level assaults, how you enter the system and you come out and you're back in that relationship. And now that criminal history is used against you when you are again convicted of assault in trying to defend yourselves. A very common scenario that I hear is of mothers who are convicted of crimes committed by their abusive partners against their children, that they didn't commit those crimes, but they are there sort of failing to protect their children on some sort of aid and abet or accomplice liability theory, and therefore held to the same level of accountability or responsibility and as the abusive partners. And I can think of a handful of clients who I've had where they actually are serving more time for abuse of their children than their partners did, even though they were not the ones who were abusing or mistreating their children. Really, every example that Professor Goodmark gave, I can think of clients that I've had, and on top of that, in the cases that we've looked at more closely to see how the state is prosecuting these cases, when the person is going through trial and looking at the criminal proceedings, that idea, the state really loses any sense of that person as being a victim of abuse. And all of sort of that language and those tropes about bad mothers and women who are acting in ways that go against sort of the social norms comes into play, and that is used against them at trial in sort of what is a shocking way, given the sort of the rhetoric or what you hear about prosecutors talking about their understanding and expertise in domestic violence, because they prosecute domestic violence perpetrators. So I would say that this is happening here in Oregon.
I mean, just on that, when we're talking about backgrounds, I mean, oftentimes people in the legal profession don't have like that background of, as trained, trauma informed, or understanding how to work with, survivors. And you often have both public defenders and prosecutors that have really no background or training in this, or very limited background. So, it can be, you're put in a position where you're not even, you have individuals that don't even know how to examine this from a psychosocial dynamic. And Professor Goodmark, I wonder if you could speak to sort of these things that we commonly hear. As Julia was mentioning, like this does happen in Oregon, but we will see, like in trial transcripts or in comments by judges or prosecutors, these kind of things like, she should have left, or they should have known better. They should have protected their children. If they really cared about their children, they wouldn't have allowed this to happen. They would have taken their children and gone someplace else, or they should have known better, those types of things. I mean, can you speak to that and how that sort of contradicts what we know about the dynamics of domestic violence? And maybe you can start off talking about these terms: domestic violence, domestic abuse, intimate partner violence. I know we kind of use them interchangeably, but like, if you have a preference for a term, if you could explain that too.
Sure. So to start with the terms, domestic violence is now considered kind of an umbrella term that encompasses not just violence between intimate partners, but also parent-child violence, elder abuse, and a variety of different kinds of violence. My work is largely focused on that violence that happens between partners. And so that's why I use the term intimate partner violence. Intimate partner abuse is kind of interchangeable as well. There's a whole debate about whether we want to reclaim the word violence or whether we want to use abuse because it's more capacious. I think those are really interchangeable, but it's really a question of that umbrella versus the individual. But within any of those topics, there are very strong stereotypes about who victims are and what they're supposed to do. And when you fail to conform as a victim to those stereotypes, that's when you become invisible as a victim. And that's why I called the book Imperfect Victims. There is a perfect victim stereotype, and that perfect victim is white and straight and middle class and cisgender and meek and weak and passive. It very much comes to us via Dr. Lenore Walker's work in The Battered Woman and the Battered Woman Syndrome. It comes to us from the history of slavery and the ways in which only white women were recognized as true women, and women of color were dismissed as not actual women and therefore not actual victims. And those stereotypes still operate really strongly. And then there are a set of stereotypes about what it is that we expect victims of violence to do. So even though our perfect victim stereotype is of someone who is weak and passive, we still expect people to leave. And we expect that even though there's research that says that leaving doesn't necessarily make you safer. And in fact, separation-related violence is a serious problem and a very real phenomenon. Or that we expect you to go to police or to go to prosecutors when you need assistance. And if you fail to do that, then you're not a perfect victim. And so the problem, of course, is that very few people can be perfect victims. Very few people conform to those stereotypes in ways that make them legible as victims by the legal system, which creates huge problems. So if you are a Black woman, it's very easy to get tagged as an angry Black woman. If you are a woman of color, then you're not proximate enough to whiteness to be a good victim. If you're a substance abuser, if you have mental health issues, if you have done sex work, but also if you have a job and you can earn your own paycheck and you take care of your own business. For people who've seen, for example, the Netflix docuseries Killer Sally, Sally McNeil is this person who is transgressive in kind of every way. She's a Marine, which is a very macho branch of the military. She's a bodybuilder. And even though her husband is bigger and stronger than she is, it's her physical size that makes her transgressive. She sells access to her body through wrestling with others. And then she's got a foul mouth. And so in all of these ways, even though there were witnesses who heard her being strangled on the night that she killed her husband, and even though there was a documented history of abuse, the prosecutor in that case said she's not a battered woman because she's a violent person. And those things can't coexist. So all of those stereotypes are operating to make it so that the path for victimization is a really narrow one. And if you fail to do those things that the system expects you to do or wants you to do, or you fail to look like a victim in any of the ways that we understand victimization, you won't be able to be recognized by the legal system.
It's always stunning to me hearing these contradictions, because either if we go to the legislature or we're talking in community forums or even talking with the Department of Justice or DAs, when you hear other testimony in support of supports for victims or victim rights or survivors, there's a lot of support, a lot of energy, funding kind of goes out the door for those support services. And rightly so, those upstream interventions are incredibly important. When we start talking about this population, the amount of work we have to do to convince people that these individuals are also victims or survivors is quite extraordinary. It's a lot of doubt. It's, these stereotypes come into play, and then this fear that everyone's going to manipulate the system, that every individual incarcerated is somehow like a very manipulative, antisocial, individual that's going to, somehow this will open up the prison doors or allow people to escape convictions or sentences. So it is really like hard to square those contradictions, like when you're confronting them. But it is like a challenge and something that we have to really work on from a public education standpoint, at least from our organizational standpoint, the way that we look at it. But Julia, I wonder if you could talk about the survey that you did. You mentioned it in some earlier remarks, but you did a first of its kind survey here in Oregon, which gave us some additional information about what's going on in Coffee Creek.
In 2017 and 2018, we did a survey of women at Coffee Creek Correctional Facility with Portland State University's Criminology Department. And we were able to survey over 140 women about their experiences from the time of their most recent arrest through to their incarceration, and what, we had questions trying to understand how they experienced the criminal process. And the idea behind this survey was largely about, I think some of the things we're talking about today, is that when we hear these stories from individuals, especially incarcerated individuals or individuals in the criminal system, there's automatically a distrust. So if I take these anecdotes that I'm hearing and I'm seeing trends in these anecdotes and bring it to lawmakers or policymakers and say something is not right here, those handful of anecdotes will be dismissed, explained away and personalized to that individual as to why there's no problem here, no issue here. And so the thought behind the survey was, can we get a collective, what would happen if we had a collective voice of incarcerated women, and they're telling us about, we have a good number of people telling us about their experiences through the process, and see what trends are coming through with that. And so we had a number of results from that survey, but one of the strongest trends was the history of trauma with incarcerated women that participated, but also the role that trauma generally played in the commission of their crimes or in their convictions, and then more specifically domestic violence contributing to their crimes, or to the reason why they were incarcerated. From that survey, just two data points: 65% of women in a relationship at the time of arrest reported experiencing abuse in their relationship. And 44% of women in a relationship at the time of arrest said the relationship contributed to their conviction. And these numbers very much fall in line with what we see in other surveys or research that's done throughout the country. And one of the reasons this was important is to show that this is also going on here in Oregon. And in addition to people sort of answering check boxes to yes, no questions, a lot of the women also just gave a brief description of what this looked like. And they described being coerced by their abusive partners, acting out of a sense of fear and under threat. They talked about the role that their children played, how their abusive partners use their children to control them, and how their partners also abuse their children or would abuse their children, and they acted out of protection for that. They expressed needing to do whatever they could to escape the relationship. They reported committing crimes to financially support themselves because of the abusive relationship left them either homeless or without money and resources. And then again, women also described being held accountable for their partner's crimes. And what really stood out to me with these descriptions is just the varying ways in which domestic abuse contributes to people being on this pathway to incarceration. And when you think about the criminal legal system and the way it's structured, and we often hear this term of this one-size-fits-all approach to criminal defendants, I think it becomes very apparent that survivors of domestic violence who come in as criminal defendants, they're sort of on an automatic pathway to be harmed and over-incarcerated, unfairly and unjustly held to account, because the criminal system is not set up to account for this variation and why people are entering the criminal system.
Yeah, the survey was, I think, really important, and we've been able to generate like a couple reports out of that based off the findings. And in the chat, you'll see the survey results there. But if you go to our website, based off the survey, I think they were a couple of different reports that talked about some high level sort of, information that we got back. So I think it's really good work. And there's still some findings that we did learn from the survey that we haven't published in reports yet. But I think from the general report, you could get a good sense of what the data is showing. I do see a question. I will come back to it because I think I want to bring Mallory in. I think she'll be able to help answer that question as well. And I'd like to get Professor Goodmark's thought on it. But Mallory, Professor Goodmark spoke to the fact that a switch is pulled, or I've used that term, I've heard her, I think, use it before, when someone becomes a defendant and they're no longer acknowledged as a survivor or victim. And Julia has mentioned, based on her experiences working in Coffee Creek, that she also has seen that. Can you talk about that as your experience as a public defender here in Oregon?
Yeah, that's absolutely consistent with what I've seen. Survivors and defendants are viewed as existing in mutually exclusive categories. And I've seen literally the same person who has come into court as a victim on a case that the state is prosecuting come in later at a future time on the other side as an accused person, and the way they're perceived by every actor in the room just shifts. The abuse that they've experienced fades into the background, and now they're just this one-dimensional defendant without any context or history. When a person is accused of a crime, it's like all anyone can see is that crime. And hearing Professor Goodmark and Julia talk about anecdotes they've heard from their clients or cases that they've worked on, it was so resonant. I've represented so many people that fit those narratives, people who have been criminalized for acting in self-defense, people who were victims of sex trafficking and were prosecuted for things they did during the course of being trafficked, people who acted under coercion, who covered for their abusive partners when those partners were engaged in, the drug trade or things of that nature. And all of their experiences as survivors just get stripped away when they come into the courtroom. And it's so hard for them as defendants and their counsel as defense attorneys to overcome that stripping away of their status as survivors.
So I think this is this segues into the question that someone's asking, and Professor Goodmark, if you will also chime in on this. The question is, do you think part of the problem is the fear of being wrong? And to follow that, the fear about damaging the reputation of prosecutors and messing with their stats. Mallory, do you want to start? And then Professor Goodmark.
Yeah, I think that it is hard. I think that is part of it, the fear of being wrong. I think that there's an investment on the part of prosecutors in the cases that they've chosen to prosecute. An important piece of context is that prosecutors don't do their own investigations. They rely on police reports that they read and the conclusions of officers writing those police reports based on investigations the officers do. And sometimes those investigations are just the officers interviewing the involved parties and deciding who they think is telling the truth. That report goes to the prosecutor. The prosecutor decides based on that report without further investigation what to do with the case. And once the prosecutor decides to pursue and press charges against somebody, I think it's very hard to convince them that they're wrong, that they are going after the wrong person, that they have a victim who's being prosecuted. I think there is a lot of fear about being wrong. And I think there's a genuine belief that the police did their job and they arrested the right person. Well, this is the person who got arrested, so they must be the one that's deserving of prosecution without really further interrogation of that line of thinking.
So I would just quickly kind of rephrase the question, which is to say, why do prosecutors bring these cases? And it seems to me there are kind of three reasons why prosecutors bring these cases. One, oftentimes they will argue that they're helping. that's a way to get somebody into services. It's a way to get them to acknowledge that there's a problem. And because we've cited so much of our social service structure through the criminal legal system now, prosecutors can make that argument with a straight face. I think two is that prosecutors bring these cases because they're winnable. Particularly with survivors of intimate partner violence, they tend to be pretty easy to prosecute. They admit what they've done. They don't try to minimize or deny it. There are lots of reasons why those cases are easy cases for prosecutors to win. And then the third is what we've been talking about, which is that prosecutors don't see people as victims at all. So that's why they bring these cases. And so, yeah, I think and then there's kind of this corollary to all of that, which is this belief that somehow it will be open season on men. And again, it's very binary when people talk about it this way, that if we don't prosecute these cases, then people will be getting away with something, and that will be damaging, particularly to men. And you see kind of prosecutors say it decade by decade, that it will be open season on men if I don't prosecute these cases, without acknowledging kind of why it is that these people are coming into the system in the first instance.
Well, thanks. That was, I think, really helpful. It's a great question. You know, as we're gonna talk about Senate Bill 1070, but so people can understand it in its context, you know, Professor Goodmark talked about the different ways in which survivors are sort of brought into the system, like the material witness, the criminal side. And I wonder, Mallory, if you could just describe, like, very quickly, when we talk about a criminal trial, we're talking about essentially sometimes how we define it as like two components of it, like the guilt phase and the sentencing phase. Can you just briefly describe what it is those things are, and that will help, I think, set some foundations for when we're explaining Senate Bill 1070.
Sure. So the guilt phase is the part of the criminal process that involves determining whether the accused person will be convicted, either because they plead guilty or they are found guilty by a judge or jury. And then once that happens, they move on to the sentencing phase, where the judge imposes a penalty for each crime that they've been convicted of.
And, you know, this will be important, as Julia explains, Senate Bill 1070, because this bill is, you know, just talking about the sentencing aspect of this, which is why, you know, we view this as a very modest and incremental kind of approach, but a very important sort of reform or change that needs to happen. Mallory, we know 95% of criminal cases end in plea agreements. We also commonly hear from incarcerated survivors that their history of domestic violence or abuse never came up. Can you walk us through the kinds of considerations you or other public defenders would be making at this time, and whether or not someone being a survivor would be one of those considerations?
Sure. So because prosecutors don't do their own investigations, they rely on what the police have already done. They're not going to receive any mitigating information about domestic violence that's going on unless and until the defense attorney provides it. And the one problem is that public defenders are generally not trained to screen their clients for domestic violence. I can say that having worked in 3 public defense offices in 3 jurisdictions, 2 different states, I don't recall ever hearing of trainings on representing survivors of domestic violence. I know there were many trainings on representing people experiencing mental illness, people experiencing drug or alcohol addiction, but domestic violence just wasn't on the radar in the same way. And I recently reached out to 5 current and former public defenders who collectively practiced in 5 different jurisdictions, and asked each of them the same question, whether they had ever received any training on representing clients experiencing domestic violence. And all 5 replied immediately with the same answer, which was no, they had not ever received that kind of training. And some public defenders take it upon themselves to self-educate about domestic violence. Some people have backgrounds that lend themselves to being informed on issues of domestic violence. But even when defense attorneys are equipped with the knowledge and understanding of how domestic violence might impact their clients and cases, they may decide that it's not worth presenting that information to the prosecutor or judge, that it's not going to be helpful. Public defenders work with the same prosecutors and appear in front of the same judges day in and day out, and they come to know what prosecutors and judges care about, what kind of mitigation they're used to hearing, what's going to be compelling to them and what's not. And in some cases, public defenders may make a strategic decision not to share information about domestic violence because they don't think it's going to do any good. The prosecutor may not believe it. The judge may think it's just an excuse, and so on. And so even in cases where the defense attorney is aware of these mitigating factors, they may not come before the court or be presented to the prosecutor.
So what I'm hearing based on the couple answers that you provided is that there's not really an incentive for a defense attorney to actually go to a prosecutor pre-trial for this, right?
Yeah, absolutely. Unfortunately, you can't really realistically go to the district attorney and say, hey, you're prosecuting the wrong person, or hey, you should be aware that what was going on behind the scenes when this person was arrested. It's truly an adversarial system, and the response from the prosecutor in that kind of situation will almost always be, well, that's a defense you can raise at trial. And because by the time someone has been arrested and charged, and like I talked about, the police have already investigated, the prosecutor has become invested in pursuing the case. I've said to prosecutors outright that, you know, you are prosecuting the wrong person. You're going after a victim. You really need to look at this case closely. And I've not had success with that. And having represented hundreds of clients, having been exposed to hundreds more cases through, you know, being around colleagues and other people in the courthouse, I can think of one case in which a colleague was able to convince a prosecutor to dismiss charges because the person accused was actually a survivor acting in self-defense. And in that one case, it took over a year of the attorney trying to convince the prosecutor that they had arrested the wrong person. It took multiple experts, and it involved a lot of luck. And that's just a really extraordinary and unusual result.
So you mentioned the defenses. So if a defendant decides to go to trial, and as you explore defenses, can you share with us how the current defenses in Oregon work and whether or not those defenses would adequately work for a survivor? And again, we're talking about this guilt phase sort of aspect of the trial when we're determining whether or not someone should be convicted of the crimes they've been alleged to have committed, right?
Sure. So the challenge is that experiences of criminalized survivors often don't fit neatly into the available legal defenses. So for example, psychological abuse that pushes a survivor to commit a crime is almost never going to fit the circumscribed definition of duress. And like Professor Goodmark mentioned, duress is not available as a defense in cases of murder in Oregon. But for lesser crimes, it's just a very narrow box that many fact patterns are not going to fit into. Similar with self-defense that occurs within the context of the cycle of abuse that so many survivors of violence experience, likewise often won't fit the legal definition of self-defense. And then another limitation on the impact of available defenses is that they usually almost always have to be raised at trial. And that means if the jury doesn't believe the survivor, who already may have been disbelieved by police, who may be convinced as a result of emotional abuse that nobody will believe them, who by virtue of the prosecution is obviously disbelieved by the prosecutor, if the jury doesn't believe that person, they're going to be convicted, and they will likely face a much harsher penalty than what they could receive through plea negotiations because of the power the DA wields in those negotiations.
So if an individual is found guilty, we then move to the sentencing phase of the criminal trial. And as you explained, like the defenses don't actually work here. So oftentimes, you know, they're going to be convicted of some crime based on actions that they've committed. So when we get to sentencing, is it possible for a court at that time to actually consider this as mitigating evidence and reduce the sentence, or sentence someone sort of more proportionate to the culpability level of that individual?
It's possible, but only under very limited circumstances when we're talking about crimes that involve mandatory minimum sentences. So in 1994, Oregon passed Measure 11, which imposes those mandatory minimum prison sentences for about 25 different crimes. And of those 25 crimes, there are a handful for which a judge can give a lesser sentence, but that's only when the crime and the accused meet specific narrow criteria. So in the vast majority of cases, once someone is convicted under Measure 11, whether because they pled guilty or they're found guilty at trial, the judge has no discretion whatsoever to give them a lesser sentence. And that means that even if the judge believes the person is not a danger, they don't deserve to be in prison, even if they're a victim, even if they deserve less time in order for their sentence to reflect their true culpability, the judge is required by law to give them the mandatory minimum sentence.
Thanks. And I did see the question in the chat. We'll try to get to it, but we're coming up against time. So I do want to get to a couple more questions and to talk about Senate Bill 1070. I think this is a good segue from what Mallory described, because now that we sort of understand how things work in Oregon, the criminal trial, what's available. Julia, can you describe what 1070 actually does, why we're supporting it, and why we introduced it with Senator Campos, and why it's important?
So Senate Bill 1070, like has just been said, only involves the sentencing component. Well, I should say the Senate Bill 1070 has three parts. The first two parts touch on the criminal proceedings, and they only apply to the sentencing phase. So the first part, the bill requires the sentencing court to consider domestic violence. And what we believe that this is significant, because if the court is required to consider domestic violence, it requires defense attorneys to ask their clients about their histories of domestic abuse and bring it into light if they are able to. And then it gives the judge the discretion to impose a lesser sentence if the defendant was subjected to domestic abuse, the abuse was a contributing factor to the defendant's criminal behavior, and sentencing the defendant to a presumptive or mandatory sentence would be unduly harsh in light of the circumstances. And so I want to be clear that what the judge is looking at is the totality of the circumstances. Oftentimes we'll hear that this concern that if this bill passes, if you say that you have a history of domestic abuse, that you're going to be able to avoid accountability and avoid prison time. That is just one piece of this. You have to show that there's domestic abuse. You have to show it's a contributing factor to your criminal behavior. And then the judge, looking at the totality of the circumstances, is able to say, this would be unduly harsh. The sentence that you're looking at, your mandatory sentence, would be unduly harsh in light of all of this. And Senate Bill 1070 then allows judges to sentence a more appropriate or lesser sentence out and depart out of the mandatory minimum sentence. The second part of the bill allows individuals who have already been convicted to petition the court for resentencing if they did not previously present evidence of domestic violence at sentencing. And this is a very critical piece of Senate Bill 1070, because we are not only talking about survivors who are currently incarcerated being able to ask for a more appropriate sentence to their convictions that have already occurred before the bill's passage. But what we commonly hear from survivors is that because of how traumatic the criminal proceedings are and the circumstances of those criminal proceedings, it is very common that they're not able to talk about the domestic violence at that time. And you'll hear that they need space, sometimes years, from that relationship to be able to come forward and say, this is what happened to me. And I want to talk about this and share my story with the court about and ask for a more appropriate sentence. So this opportunity for resentencing is very important. An important piece. The final piece of the bill creates a task force to make recommendations to the Oregon Department of Corrections as to programs and services that are needed to ensure that incarcerated survivors of domestic violence return to the community healthy and safely, and make recommendations as to changes needed in the department's current prison operations and protocols to prevent further re-traumatization. We know that prison is an inherently traumatic environment. What our hope here is that we can start that conversation and start recognizing survivors of abuse who are in our prison systems, and start bringing together experts, the Department of Corrections, trauma experts, domestic violence advocates to start looking at this population and ask the question, how are we treating these individuals? What kind of services do they need? And what kind of changes do we have to make in the prison so that we're not constantly on a day-to-day basis re-traumatizing people? So those are the three components of the bill. I would also add to that, the idea behind this bill is really recognizing this population. And one of the hopes for this bill is that it makes people pause, at least for a moment, in the decisions that they're making, to think about when we are sentencing survivors to prison, to at least have it in their conscience that we are putting abuse survivors into an abusive environment, and to like have that at the forefront of the decision making that people have at sentencing.
Thanks. If people want to learn more about the bill, I put into our chat a website that we've created for Senate Bill 1070. We're just past an hour, so I'm just going to try to ask a couple more questions of Professor Goodmark and Mallory and some concluding remarks. First, I just want to thank everyone for their conversation today. I think, like, as you can tell, we could probably talk about this for, like Julia said, we've had 2-day conferences about this subject matter previously. So there's a lot to sort of unpack here. But Mallory, based on what Julia said, she alluded to it, but how would this actually change the dynamics for someone for you, if you're a public defender representing an individual, and possibly sort of that engagement with the prosecutor? Like, how does this alter that sort of process now if this bill were to pass?
Yeah, so the mitigation that defense attorneys pursue is generally guided by statute. The law spells out certain factors that can be used to pursue a lesser sentence. And those factors are the things that defense attorneys typically screen for when evaluating what mitigation exists in a given case. So, for example, by statute, symptoms of mental illness may be used to show that a person didn't have the intent to commit the crime charge, or they may be used to argue for a lesser sentence. And because it's so important, and because it's written into the law, mental illness is always screened for by a competent defense attorney. And in part, because it's the law, prosecutors and judges more often take that kind of mitigation seriously. Not always, but more often. Senate Bill 1070 would ensure that defense attorneys likewise screen for domestic violence in each case, ensuring that relevant mitigating information be presented to the court for consideration. And I think it would really foster a culture shift in which prosecutors and judges are more receptive to that kind of information.
And Professor Goodmark, one of the things that we heard, we introduced a version of this bill in 2021, and one of the sort of criticisms that we heard is, well, now judges are going to act and depart out of mandatory minimums, and everyone's going to get like these lesser sentences, and it's going to be basically people escaping some sort of accountability. Our experience in Oregon is that our bench is it's kind of moderate, in the middle, small c, kind of conservative. But when you hear things like that, we've talked about the training of public defenders, prosecutors, judges. What is your sort of experience with like these stakeholders actually understanding this issue? How much education do you think is going to be required? This is not something that's just like known by folks. And I saw in the chat you put talking about like judges sort of understanding of this issue, but like, what are we talking about based on your experience?
My job was to train judges on intimate partner violence for 3 years. And I'll tell you that as a general rule, those who are interested in it understand it and learn about it, and those that don't, unless, as Mallory said, there's some reason why they have to. And so requiring people to take intimate partner violence, to take domestic violence into account will do more than any training would ever do to have proper attention paid to this issue. And that doesn't mean it's perfect. We still have to be attentive to the fact that even in places that have laws like 1070, there are still ways that judges find that the domestic violence didn't matter. So it's not as though this is kind of the be all end all. It's the first step that we need to get judges and prosecutors to take this more seriously, but it's not the end. I think the concern is, well, everybody's a survivor of violence. Well, yeah. And so we should care about that. And we should think about the reasons why we ask that people be held accountable. And we teach law students that there are 4 theories of punishment. There's incapacitation, rehabilitation, deterrence, and retribution. And we're pretty clear. I mean, yeah, if you want to incapacitate somebody who's been a victim of violence, I guess that could be your motivation. It certainly wouldn't be mine. That deterrence does not work, and it doesn't work generally, and it doesn't work for this. That no prison is rehabilitating anybody, and that really what we're talking about is retribution, not accountability. And when we talk about retribution, we talk about kind of the idea of equivalence. For people who've already suffered so much, the idea that prison gives some kind of equivalence is just ridiculous. It's just adding injury to injury at that point. It's not fulfilling our goals for accountability. And then, heaped on top of all of that is the fact that the criminal legal system neither decreases nor deters intimate partner violence more generally, which is the topic of my second book. And so it's not working. It's not doing the work that people think that it's doing. And so to have this fear that all of a sudden we won't be holding people accountable, we're not holding people meaningfully accountable now. There are so many other ways to do accountability other than by sending them into a trauma-inducing system, particularly when they've already been victims of trauma.
Yeah, I think that's, since we're past time, I think that's a really great way to sort of begin to wrap things up. I do want to just ask Julia, Mallory, and Professor Goodmark, if there's one thing in a short statement that you would want people to know about this bill, this issue, what would that be? I'll start with you, Julia.
I think that I would like to emphasize that we have to start addressing and caring about all survivors of domestic violence, and that Oregon should take this opportunity to support Senate Bill 1070. This is a modest step. As we've heard today, this is a very large issue. And if we're really talking about justice and care and safety for survivors of domestic violence, what we're asking for with Senate Bill 1070 is just a modest step. But this is a very significant step that we take, because like Professor Goodmark said about training of judges, training of prosecutors, training of defense attorneys, that only matters if there's a requirement in law that it matters. And so this is one of those steps that it applies only at sentencing, but I believe that this creates a ripple effect to the broader conversations that we can start bringing this issue into light, start really looking at what we're doing with survivors, really start looking at how we're using the criminal legal system to address harms in our community and asking ourselves, is this working? But there is such an opportunity right now for Oregon to do something very significant and support all survivors of domestic violence and support the passage of Senate Bill 1070.
And I'll mention how people can support that in just a moment. Mallory?
I would really like people to know that the distinction between survivors and defendants is completely artificial. Our criminal legal system perpetuates this black and white thinking without leaving room for the reality that people are complex and multifaceted. And I think that our job as advocates is to recognize those complexities and gray areas and push for policies and practices that acknowledge that there is a class of victims much bigger than the group of people police or DAs label as such. I think survivor defendants are prosecuted and sentenced without regard for the violence they've experienced, and they deserve better from our legal system. And I think Senate Bill 1070 is a step in giving them that.
Professor Goodmark?
Long mandatory minimum sentences are not decreasing intimate partner violence. They're not deterring intimate partner violence. And for people who are acting out of self-defense or under duress or under coercion or who are self-medicating, they're not doing any of the work that we think that they're doing. They're unnecessary, and they're deeply, deeply traumatic for the folks who experience them, who are put away and feel like they've been forgotten altogether by society, that their trauma didn't matter and doesn't matter. And so for that reason, I think 1070 is so important.
Well, I just want to thank all three panelists. Professor Goodmark, it's been really great to be able to host you. And I would say, I'll tell you how you can support 1070, but you can go get her book. take a look at it. It's a really thoughtfully written, well-written book about this issue. How you can support this bill. Right now, we're going to have a public hearing on the bill on March 28th. If you're willing to write testimony, please go ahead and submit testimony. You can go to the Oregon Legislative website, look for bills. We'll have some action alerts coming out next week that will provide some instructions, guidance on that. If you work for an organization that would like to support Senate Bill 1070, we're still looking for more organizations that work with survivors, that work in this space, and non-traditionals. Like we're currently trying to secure support of businesses in the business community, like Salt and Straw, to help support this bill. So if you work for an organization or a company, it'd be really great to get additional support, and we can work with you to help figure out how to get the information to those decision makers. And then just tell people about this, talk to them, let them know that this bill is moving, reach out to your senators. It is in Senate Judiciary. It was scheduled for a public hearing on March 28th. There's 5 members of Senate Judiciary. You can look it up on the Oregon Legislative website. Please reach out to them and tell them to vote yes on this bill. It'll be scheduled for a work session in which they'll take a vote on whether or not this bill moves out of committee and keeps moving forward in the legislative process on April 4th. So we really need people to reach out to their representatives and senators, especially the senators, and let them know, and Senate Judiciary members, that this is an important bill to move forward. I want to thank everyone for joining the webinar. Again, this is hosted by the Oregon Justice Resource Center. You can find out more information at our website at ojrc.info. We have recorded this webinar, so we're going to make it available very soon. So you can please share this with, so you'll be available to share. Please do share it with other people. We'll also have an audio recording that will be uploaded to the podcast that's associated with our organization. Again, just want to thank everyone for participating in this webinar, and look forward to moving this bill and continuing to work on this effort and creating some justice for all survivors in Oregon and in this country. Thank you, everyone.